Sometimes the best defense is a good offense, and sometimes it's not. Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. And today we have an insurance dispute. Oh boy, my favorite kind. Mostly because over the years the insurance companies have paid me some significant money by virtue of solving disputes for them. So I've almost always managed to solve them unfavorably toward the insurance company, I might add. So I don't have any animus toward insurance companies. I love them. They've kept me in business. But the long and short of it is the insurance disputes are always interesting because it's amazing how twisted you can get language, and until you've read an insurance policy, you have not really twisted your brain on much of anything. This is an interesting part of the case that we discussed yesterday involving DuPont and the PFOAs and PFAS chemicals and the forever chemicals that the state AGs are objecting to the class settlement on. This is filed in that same multi-district litigation, and I'll be honest with you, I don't think it belongs there, and that's part of what we're going to talk about today. So you may recall in the petition that was filed for writ of certiorari involving DuPont that one of the amicus briefs that was filed by Tyco Fire Products. And the reason that's important is because Tyco is at the heart of the problem in this case. There are two complaints and one motion to dismiss that I want to work through here and give you a little bit of insight into what goes on in multi-district litigation, as well as what goes on when you file cases in different venues and different courts in order to try to gain an advantage over your opponent. It rarely works out well for you, but people continue to try it, and even lawyers with big name firms try this. So we'll start with Tyco's complaint in South Carolina. And I want to point out to you something at the outset, which is at no point in this complaint does Tyco ever mention the fact that they've been sued by federal insurance, and that suit involves the same parties that are at issue in this lawsuit. They don't mention that about Marinette, Wisconsin, and the case that's going on there. And one of the things that my boss used to say is you need to get caught 3 times telling the truth in order to gain credibility with a judge. And when you hide something from a judge and somebody else points it out, it automatically makes you look bad. So one of the first things that I noticed about this complaint was it made no reference to any other ongoing litigation. And of course, that's going to be relevant to the federal judge who has this huge multi-district litigation going on in his court. Most likely the last thing he needs is another case filed directly in his court when it has zero connection to, well, maybe not zero connection, but a very tenuous connection to South Carolina. Let's look at that complaint now. So this is Tyco Fire Products' initial complaint in the South Carolina District Court. And basically it says this is an insurance coverage dispute between itself and the named insurance companies here: AIU, American Guarantee, American Home Assurance, Great American Assurance, Insurance Company of the State of Pennsylvania, National Union Fire Insurance Company, New Hampshire Insurance Company, Star Indemnity and Liability, Swiss Re Corporate Solutions American Insurance Company, and Zurich American Insurance Company. Quite a few of those companies there. Tyco's been named as a defendant in suits brought by individual claimants, including current and former military and civilian firefighters who and private water providers who have been damaged as a result of Tyco's products made with this aqueous film-forming foam. And these suits have been in various state courts throughout the country. Defendants' policies described herein consist of primary insurance, which is the insurance that is initially responsible for damages up to a fixed limit; umbrella, which is the next level of coverage, which will give you, perhaps another $7, $8, $9 million in coverage; and excess comprehensive general liability policies for the policy periods from 1990 to 2016. So each of these policies requires each of the applicable insured defendants to provide a full defense in connection with the AFFF suits, pay all costs and expenses, satisfy any legal liability, and they allege a coverage occurrence, seek damages for bodily injury and property damage and personal injury as those terms are defined in the policy. And Tyco has satisfied all the terms and conditions, so it wants declaratory relief. It wants the court to say that Tyco gets a full investigation and defense in connection with the suits and that they pay in full all legal liabilities. Plaintiff further seeks declarations that each umbrella and excess insurer has a duty to defend and pay. And then it lists all of the parties and how they're related. And although normally you find this at the beginning of the complaint, here we find jurisdiction and venue more toward the middle because this court has diversity jurisdiction under 28 U.S.C. 1332. But in order to have diversity jurisdiction, there has to be a tort committed in the state or a contract that was breached in the state. And although you can supposedly make that out from the breaches of any contract that occurred in South Carolina, you probably can't make that out for nationwide, and that's what they're seeking is nationwide relief, because this is a multi-district litigation panel. So they say you can exercise personal jurisdiction, Judge, but that's going to be the heart of the motion that is filed by the insurance companies. Each defendant is supposedly subject to personal jurisdiction in this, and they say they get to file it because of the case management order. So in the factual background, they talk about the AFFF suits. There's 4,000 of them, and they involve PFAS and basically these aqueous film-forming foam products that are manufactured, distributed, and sold by Tyco. So they go through the policies and all the policy numbers and policy periods. None of that is particularly relevant. And they seek declarations as to the interpretation and meaning of the policies identified herein. And then they go through all of the policies and all of the questions they have about those. It says the immediacy of this controversy justifies this court's exercise of authority to issue a declaratory judgment determining the duties and obligations of the parties. And they seek a declaratory and injunctive relief from this court in order to remove and afford relief from uncertainty and insecurity with respect to its rights. So then they have a prayer for relief, which is where they ask the court for the relief that they want, and then they demand a trial by jury on all issues so triable. Anything that deals with the interpretation of an insurance contract is going to be a legal question. That'll be handled by the judge, but if there are any facts that relate to that, then that would be handled by a jury. And then the local counsel is a guy from Columbia, South Carolina, whereas the people who are really driving the boat here are from Morgan, Lewis, and Bacchius in Washington, D.C. So one of the differences between state and federal court in many respects is that in state court you usually have to plead a plethora of facts to establish your right to relief. Certainly that's true in Missouri. But in federal court, all you have to do is notice pleading. You have to put the other party on notice that you're suing them for a particular claim. And you do have to plead enough facts to lay out the elements of the claim, but you don't have to go into great detail. And indeed, that's what they've done here. They've put together a complaint that essentially says we want a declaratory judgment that defines our right to protection and reimbursement and coverage of our expenses pursuant to these policies. And again, they don't mention the fact that they've been sued in another venue. And for that reason, one of the first things the court did after it got this complaint, and after the defendants filed a letter with the court saying, hey, this case is already ongoing in Wisconsin, is the court said file all of the documents and all of the motions and all of the exhibits from the case that's on file up in Wisconsin, which they did. Which is how I got the complaint in the Wisconsin case. So let's take a look at the complaint in the Wisconsin case, and it's not filed by Tyco. So let's take a look at that. The complaint that was filed in the state of Wisconsin in Marinette County, and it was filed by the insurance companies, Century and Federal and Ace, and they are suing Tyco for a number of things, but the plaintiffs are insurers, and they seek to enforce the terms of a confidential settlement agreement between Century and defendant Tyco Fire Products. They reached that settlement in 2011 after 8 years of litigation in this court regarding underlying environmental claims against Tyco. Yet, Tyco has now improperly sued them in South Carolina. Century, American, and Federal all seek various declarations as to the rights and responsibilities of the parties with respect to any insurance coverage obligations. Also named as defendants are certain other insurers that issued or allegedly issued insurance policies under which Tyco Fire has sought insurance coverage in South Carolina. Tyco Fire, long headquartered in Marinette, is currently seeking insurance coverage for a South Carolina court. That's the case that was dismissed. So, the insurance coverage dispute arises out of underlying suits for asbestos, product liability, a class action product liability, and individual product liability brought by various entities, 2 actions brought by the Wisconsin Department of Natural Resources, and 1 class action alleging that Tyco's use and distribution of fire safety products have caused environmental damage or injury. So it goes through and lists the plaintiffs and their home bases and their principal places of business, and goes through jurisdiction and venue in rather summary fashion. It says, look, we have jurisdiction over Ansel because it's a resident of Wisconsin. They don't ever try to say that they have jurisdiction over the other insurers simply because of Ansel, so I'm not really sure how they have personal jurisdiction over them. So they go through and they list the policies, and each of the policies was issued to Tyco Fire. Each contains an exclusion which precludes coverage for claims involving pollution-related claims or liabilities. And it's sort of at odds with what Tyco has said. Each of the plaintiff's policies provide coverage only for damage or injury that occurs during the period of particular policy. So they were engaged in this litigation, and they resolved it by virtue of a confidential settlement agreement. And because it's a confidential settlement agreement, they redact all of the important information related to the settlement agreement. And of course, the court can read this, but basically they're bringing the suit to enforce the settlement agreement against Tyco Fire. So they ask for injunctive and declaratory relief. And that means that Tyco would be enjoined from suing them in another jurisdiction. And they ask for declaratory relief, basically saying, hey, the policy doesn't cover the things you say it covers. And then they ask for a declaratory judgment regarding the application of pollution exclusions, which is a clear question of contract interpretation, which will be decided by the judge. And then they ask about the asbestos claims and that sort of thing. This complaint goes on for 109 pages, and it goes through all of the different insurers, all of the different complaints, all of the different policies. And of course, we don't know very much about what is really at issue because they redacted the part about the confidential settlement agreement. Well, as you can see from the listing of all the insurance companies and all the insurance policies there, it's pretty clear that the same parties that are involved in the South Carolina suit filed in the MDL are very similar to the parties that are involved up in Wisconsin. And that case was filed first. It's already ongoing. The parties are in a different position in Wisconsin in that Tyco is a defendant instead of a plaintiff, but that really doesn't matter because what the parties are asking for is the construction of the agreement. So I don't know whether it's a ruling that they got from the judge in Wisconsin that makes them think they're not going to get a fair shake, or whether it's some other tactical or strategic thought that they've had that they have to come to South Carolina. But they absolutely should have mentioned the fact in that South Carolina case that they'd already had this case filed against them up in Wisconsin, and they didn't do that. So when somebody gets hit with a lawsuit that they don't expect and it doesn't, at least on the face of it, seem to have much merit, the first thing that happens is somebody files a motion to dismiss. And that's what's happened here. Let's take a brief look at the motion to dismiss filed by Zurich. Motion to dismiss that's filed by Zurich and American Guarantee and their memorandum in support of their motion to dismiss. and herein they talk about all the reasons why this court shouldn't be handling this dispute. The complaint filed by Tyco and pending before this court is the third iteration of the same insurance coverage lawsuit. That's not a good thing. And the first lawsuit was filed in October 7th, 2022 in the Court of Common Pleas in Richland County, South Carolina. That's the first case that was filed by Tyco, and it was later dismissed because of a lack of personal jurisdiction. And that was done by the former Chief Justice of the South Carolina Supreme Court. And if she didn't find personal jurisdiction, it's unlikely that the federal judge is going to. So while the litigation is ongoing, Federal Insurance Company filed a second case in the Circuit Court of Marinette County, Wisconsin. Now this is important because Tyco is headquartered there, and indeed the Wisconsin action has been proceeding apace. There's a case management order in place, and discovery is ongoing, and dispositive motions have been filed. Zurich was then surprised when in the midst of that, Tyco filed this case again back in South Carolina when they'd lost on personal jurisdiction to begin with. So these are the things that they say the court should dismiss on. First, it's direct filed in this complaint, and it's not supposed to be. Multi-district litigation usually has lawsuits transferred into it. It's unusual to see a direct filed action, particularly when the action concerns this AFFF case, or these AFFF cases, and this is basically an insurance coverage dispute. So there's no specific personal jurisdiction over the insurance companies because they're non-residents of South Carolina, and the disputed issue doesn't involve South Carolinians. South Carolina has a statute that closes the door to the courthouse on non-resident plaintiffs in a situation like this. The doctrine of forum nonconvenience strongly suggests that the first filed, far more comprehensive and more advanced Wisconsin action get handled first, and this court has the authority and the discretion to basically abstain from accepting jurisdiction in this case, which is what they asked them to do. I'm not a big fan of motions to dismiss generally because, for the most part, a motion to dismiss, if it's filed against you as the plaintiff, just gives you notice that you have some deficiencies in your complaint that you can shore up with an amendment to that complaint. And that's inevitably what happens, and when it does, usually the motion to dismiss is denied. So, you know, the process of a motion to dismiss is that you file the motion, they respond, you reply to their response, and then the court issues a ruling. And it issues a ruling based on the pleadings and anything attached to the pleadings, and then it comes down to a matter of law. Do you have the right to proceed or not? And in this case, they raise a number of issues. They raise the specific personal jurisdiction in that this does not arise out of a discrete dispute in South Carolina against these insurers. And that's because while there may indeed be some cases involving them in South Carolina, they did not mention those and they didn't cite them as the specific reason why they have jurisdiction. And I think the insurance company does a pretty good job of pointing that out. And then the other thing they talk about is forum nonconvenience. Forum nonconvenience. I've done a video on this before, but basically what it says is this court is too difficult for me as the defendant to come and defend in. Now, let's be honest. Zurich is a big insurance company with, you know, its lawyers in Washington, D.C. could probably go anywhere and defend. And indeed, if they're writing policies in South Carolina, they could easily go and defend there. They probably have, at least to a certain extent, some general subject matter jurisdiction down there, but not any personal jurisdiction that is tied to this particular case. In other words, it doesn't arise out of an act by Zurich in South Carolina. So that's going to make it hard for Tyco to stay in the state of South Carolina. Plus, even though it's unlikely to show up as something that is dismissed for forum nonconvenience, they do have good grounds to, basically ask the court to abstain from taking action because there's a prior suit involving the same parties that was earlier filed in a state court. And the federal courts have an abstention doctrine where they say, look, if there is a state court action pending over the same subject matter, generally speaking, we're going to abstain and allow the state court to handle state law issues. The only thing the federal court would actually have jurisdiction over would be the federal subject matter questions, questions related to federal law. And in this case, I suppose some of the environmental laws might provide a hook to jurisdiction. But this is an insurance dispute. Insurance disputes are interpreted based on the contract law of the state where they're issued. That's going to be Wisconsin. And as a result, there probably is a really good reason for the district court in South Carolina to abstain on this particular issue. So we'll have to see what the court does on this, but I thought it was an interesting case to show you how, particularly in these business-to-business sorts of litigation, they go out and they hire these big-name lawyers who are $500, $600, $700 an hour lawyers to go head-to-head. And then when you actually get into court and look at the meat in the lawsuit, it's spoiled. Sorry. It's just one of those things where Tyco should never have filed this in South Carolina. And I'm actually surprised that a Washington, D.C. law firm would insist on filing it. One of the things that I frequently say is that kindness heals wounds the human eye can't see. And if you have the opportunity to be kind to somebody today, please take advantage of that. Have a marvelous day. I will catch you on here next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.